Well, this seems to be a case of one Flynn, two films. Viva Frei, Montreal litigator turned YouTuber, and it is the latest development in the never-ending saga that is the Michael Flynn judicial saga. A full panel of the Court of Appeal has heard Judge Emmett Sullivan's petition for rehearing en banc. They have granted it, returned the entire Michael Flynn file back to Judge Emmett Sullivan, including his appointment of an amicus in the file.
Yes! 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 Yes!
Now, I cannot possibly do a summary of all of the facts. I'm taking for granted that if you're watching this video, you are sufficiently familiar with what is going on in the Michael Flynn judicial saga. I just want to summarize the procedure that is at issue here. We all know that Michael Flynn pleaded guilty. We know that subsequent to the disclosure and communication of highly exculpatory evidence, Michael Flynn sought to withdraw his guilty plea. In light of that highly exculpatory evidence and evidence of government misconduct, the Department of Justice made a motion to dismiss the criminal complaint against Michael Flynn, basically a motion to dismiss the charges. Typically, when the government files a motion to dismiss the charges, the judge has very little discretion, if any, in determining whether or not to grant that motion to dismiss, but the judge does nonetheless have some discretion. But Judge Emmett Sullivan, in exercising his discretion, said, I'm not going to grant the Department of Justice's motion to dismiss just yet. I want to hear arguments in opposition to the government's motion to dismiss, and because no one's there to present those arguments because the government is in favor of the motion to dismiss, he appointed an amicus to present those arguments. An amicus is literally Latin for a friend of the court, and sometimes that friend of the court is a little more friendly to the court than others. Michael Flynn, through counsel, comes in and says, whoa, Judge Emmett Sullivan, you have no discretion not to immediately grant the Department of Justice's motion to dismiss, so I'm filing for a petition of writ of mandamus from the Court of Appeal ordering you to dismiss the charges as per the Department of Justice's motion. That petition for the issuance of a writ of mandamus went to a panel of 3 judges of the Court of Appeal, and in a split decision 2-1, they spanked Judge Emmett Sullivan for what he did. In a pretty scathing decision, they basically said, Judge Emmett Sullivan, you have no authority to do what you are doing. You are overstepping the bounds of the judicial branch, and what you are doing is effectively unconstitutional. You ought to grant the Department of Justice's motion to dismiss, and because you're not doing it, we're going to order you to do it. Seemingly unhappy with the panel of 3 judges' decision, and understandably so, Judge Emmett Sullivan petitioned for a rehearing en banc, meaning that the entire panel of the Court of Appeal should rehear it and redecide the issue. And the full panel agreed to rehear the issue. They vacated the original Court of Appeal decision, they reheard the issue, and they just rendered a judgment. Now, I have been following this story for months and vlogging on it for months at each stage of the proceedings, if only to make sense of it to myself, and I have an entire playlist of all of the vlogs on the subject. I'm going to link it right here if you haven't seen it. But my original prediction before this went to the panel of 3 judges was that they were just going to refer it back down to Sullivan with a heavy-handed warning. You know what you need to do, just do it and stop messing around. My prediction, and I'm crossing my fingers I'm right because I'm going to look so smart in hindsight, is that the Court of Appeal is going to say, this is all fine and well, Judge Sullivan. You can do this on your own in the absence of an amicus. You have meticulously laid out all the questions that can be asked on the Department of Justice's motion to dismiss, and you have the authority to ask them, so go ahead and ask them. You didn't need to unilaterally appoint an amicus. You didn't need to create a schedule that would add additional months to a matter that has already been going on for years. You already have the requisite authority to ask all of the questions you outlined in your argument brief. Go ahead and ask them. Render a decision on the Department of Justice's motion to dismiss, and if people don't like that decision, they will appeal it. And lo and behold, that is effectively exactly what has happened, with the exception of them not undoing the appointment of the amicus, but that is effectively exactly what has happened in the most recent judgment in this case. Now, we're going to go over the decision, but I'm only going to go over the majority opinion because the dissenting opinion of Judge Rao and Henderson is effectively the majority decision from the original judgment that was brought before the full panel. In case that's not clear enough, Judge Rao and Judge Henderson, who are the dissenting opinion in this particular judgment, were the 2-1 of the original decision granting the mandamus. And just to set the stage before we get into the majority opinion, I actually want to go over what Judge Griffith said halfway through this decision. Griffith, circuit judge, concurring. In cases that attract public attention, it is common for pundits and politicians to frame their commentary in a way that reduces the judicial process to little more than a skirmish in a partisan battle. The party affiliation of the president who appoints a judge becomes an explanation for the judge's real reason for the disposition, and the legal reasoning employed is seen as a cover for the exercise of raw political power. No doubt there will be some who will describe the court's decision today in such terms, but they would be mistaken. And here's the thing, Judge Griffith is in fact perfectly describing what in fact seems to be a very prevalent problem in the judicial system, and just saying don't worry about it is not going to appease anybody. When you can in fact predict with virtual 100% accuracy where a judge is going to go based on their political leanings, there is in fact a problem. Now, I fully recognize that this is in fact a double-edged sword that cuts both ways on the political spectrum. It remains a problem nonetheless, and it is why people are losing faith in the judicial system itself. The other thing that Judge Griffith says goes full circle back to my initial prediction, that being a stark warning for Judge Emmett Sullivan and what he has to do when they return the file to him. Moreover, as its counsel repeatedly stated at oral argument, the district court may well grant the government's motion to dismiss the case against General Flynn. Tiny parentheses, it is encouraging to see Judge Griffith being respectful and referring to Michael Flynn as General Flynn. And I'm getting hot in this car. I'm gonna open up the sunroof. Paid $17 extra a month for this car to get the sunroof. I'm gonna use it. Okay, and this is the important part. Let me just turn the car back off. This is the important part. In fact, it would be highly unusual if it did not, that is to say, grant the government's motion to dismiss the case against General Flynn, given the executive's constitutional prerogative to direct and control prosecutions and the district court's limited discretion under Rule 48A, especially when the defendant supports the government's motion. But if the court denies the motion, General Flynn has multiple avenues of relief that he can pursue, and because he does, mandamus is not appropriate in this case at this time. And this was effectively my reasoning from the beginning, that the court was just going to say, look, we're going to send it back to you, Judge Emmett Sullivan, with a stern warning. You know what you pretty much have to do, and if you don't do it, then we will spank you on appeal. But there's another reason for which I predicted this. Anyone who has ever practiced law knows that judges do not like making interim decisions that effectively determine the outcome of the file, and I think I have to close the sunroof again because it's just getting too darn loud. Okay, sorry about that. Judges do not like rendering interim decisions that effectively impact the outcome of the file. They prefer to let the judge on the merits render that final decision. So in as much as possible, a judge will punt off to the judge on the merits any decision that will have an impact on the outcome of the file because they don't want to render those decisions on an interim basis. And that is exactly what they're doing here. They're just punting it back to Sullivan, render your decision, and if it's the wrong decision, then we will intervene. And let's hear why the court comes to that conclusion. As to the petitioner's first two requests, to compel the immediate grant of the government's motion and to vacate the district court's appointment of amicus, petitioner has not established that he has, quote, no other adequate means to attain the relief he desires. We also decline to mandate that the case be reassigned to a different district judge because petitioner has not established a clear and indisputable right to reassignment. We therefore deny the petition. And just to clarify, the petition that they are dismissing here is Michael Flynn's petition for the issuance of a writ of mandamus because they are rehearing that issue that was initially presented to a panel of 3 judges. The Court of Appeal in a majority 8-2 decision is dismissing Michael Flynn's petition for the issuance of a writ of mandamus, not vacating the appointment of the amicus, and not reassigning the case to a different judge.
Did that go the way you thought it was going to go? Nope.
We have discussed the criteria for the issuance of a writ of mandamus in previous vlogs. It's actually the easiest legal question in this decision, so let's just go over it very quickly. Under governing law, the writ of mandamus should issue only if 1. Quote, the party seeking issuance of the writ has no other adequate means to attain the relief he desires, end quote. 2. Quote, the petitioner satisfies the burden of showing that his right to issuance of the writ is clear and indisputable, end quote. And 3. Quote, the issuing court, in the exercise of its discretion, is satisfied that the writ is appropriate under the circumstances, end quote. Cheney. And what absolute unbridled total discretion that third criteria gives to the court. All 3 requirements must be satisfied, and the absence of any one compels denial of the writ. Quote, as this case implicates the separation of powers, the Court of Appeals must also ask, as part of this inquiry, whether the district court's actions constituted an unwarranted impairment of another branch in the performance of its constitutional duties. Here, petitioner and the government have an adequate alternate means of relief with respect to both the Rule 48A motion and the appointment of amicus. The district court could grant the motion, reject amicus's arguments, and dismiss the case. At oral argument, the district judge's attorney effectively represented that all of these things may happen. But this is the key part that is very difficult to disagree with. Even if the district court were to deny the motion, there would still be an adequate alternate means of review, perhaps via the collateral order doctrine or a fresh petition for mandamus challenging the denial. And certainly on direct appeal by petitioner following sentencing. Petitioner has not cited any case in which our court or any court issued the writ to compel a district court to decide an undecided motion in a particular way, i.e. when the district court might yet decide the motion in that way on its own. Now, I disagree with this in part. I don't think that Judge Emmett Sullivan didn't decide anything. I think he in fact did decide something by appointing the amicus and ordering a schedule which greatly prolonged the trial for Michael Flynn. I think he did decide something, it just wasn't on the merits of the Department of Justice's motion to dismiss, and the Court of Appeal is basically saying, look, whatever he decides on the merits of the Department of Justice's motion to dismiss can be subject to appeal, therefore you have other alternative remedies. Hence, the issuance of a mandamus is inappropriate at this stage. Now, the question then becomes one of irreparable harm, and the court addresses this as well, but be prepared to disagree with their reasoning. Nor can we conclude that the government will suffer any irreparable injury without mandamus. The panel majority, while acknowledging that the government had not petitioned for the writ, centered its Cheney prong 1 analysis entirely on the harms that would befall the government in the absence of mandamus.
Mandamus Mandamus.
The district court's actions will result in specific harms to the executive branch that cannot be remedied on appeal. The dissent takes the same tack. We need not decide the propriety of considering the government's harms as opposed to the petitioners, because it is simply not the case that the executive will be irreparably harmed by the procedures ordered by the district court, such that mandamus should issue to forestall them. Even assuming denial of the government's Rule 48A motion would raise the same separation of powers issues, the procedural posture of this case is quite different. Fokker dealt with the separation of powers harms that followed the denial of the government's motion. This case raises a different set of alleged separation of power harms from the still unfolding process of deciding the government's motion. And at this stage, those harms are speculative, especially when the arguments advanced here against that process were not first presented to the district court by petitioner or the government. Quite simply, the only separation of powers questions we must answer at this juncture is whether the appointment of an amicus and the scheduling of briefing and argument is a clearly, indisputably impermissible intrusion upon executive authority, because that is all that the district judge has ordered at this point. We have no trouble answering that question in the negative, because precedent and experience have recognized the authority of courts to appoint an amicus to assist their decision-making in similar circumstances, including in criminal cases, even when the movement is the government. Flynn and the government argue that the process itself is the irreparable harm, and 8 of the judges of the Court of Appeal say no. But my personal favorite part of the entire judgment, going back to what Judge Griffith said at the beginning of this video, when it seems that judges are arguing from conclusions as opposed to towards them based on political orientation, wait until you read this passage. The dissent suggests that our approach here is inconsistent with In re Hillary Rodham Clinton and Cheryl Mills, ignoring the fact that we denied the writ as to petitioner Mills because she had an adequate alternative means to seek relief, the same reason we deny it here. We granted the writ as to Clinton, the other petitioner, because unlike here, she did not have an adequate alternative remedy under our precedent. And because, unlike here, the district court had actually ruled on the motion at issue. And, of course, we found that the ruling was a clear abuse of discretion under our precedent. And bearing in mind, all that was at issue in the Hillary Rodham Clinton case was whether or not she be deposed as ordered by the court, and it is highly arguable that she had no other alternative remedies to the relief sought. Incidentally, Robert Barnes and I did a live stream on that. I will post a link to the highlight of that particular section right here. Give it a watch because it's very, very interesting. Now let's get into the question of reassignment of judge. We also declined to mandate the reassignment of this case to a different district judge, though here the petition stalls at Cheney's second prong. Our precedent is clear that because, quote, the injury suffered by a party required to complete judicial proceedings overseen by a disqualified judicial officer is by its nature irreparable, end quote, mandamus is an appropriate avenue for seeking compelled recusal where the party seeking the writ demonstrates a clear and indisputable right to relief, end quote. But this court, quote, will reassign a case only in the exceedingly rare circumstance that a district judge's conduct is so extreme as to display clear inability to render fair judgment, end quote. Petitioner points to the district judge's failure to grant the government's motion, his appointment of amicus, and his plan for a briefing schedule that addressed potential submissions by other amici as, quote, bespeaking a judge who is biased against petitioner, end quote. But, quote, judicial rulings almost never constitute a valid basis for a bias or partiality motion, end quote. Okay, I can agree with this. A judge is not biased because he sentences a convicted murderer to life in prison. It's the second argument that I think more people are going to have a problem with. Petitioner also argues that several of the district judge's statements evidence the district judge's, quote, outrage, end quote, and, quote, deep-seated antagonism, end quote, warranting reassignment. And quoting the judge, quote, arguably you sold your country out. The court's going to consider all of that. You could be incarcerated, end quote. It could be that any sentence of incarceration imposed after your further cooperation would be for less time than a sentence may be today. I can't make any guarantees, but I'm not hiding my disgust, my disdain for this criminal offense, end quote. Quote, hypothetically, could he have been charged with treason, end quote. Quote, I was just trying to determine the benefit and the generosity of the government in bestowing a benefit on Mr. Flynn. I'm not suggesting he committed treason, end quote. Says the judge who just opined as to whether or not Michael Flynn could have been charged with treason. And bear in mind, these are all things that Judge Emmett Sullivan actually said in open court, knowing full well the media would broadcast it all over the airways forever. And how does the court get around this? Opinions formed by the judge on the basis of facts introduced or events occurring in the course of proceedings do not constitute a basis for a bias or partiality motion unless they display a deep-seated favoritism or antagonism that would make fair judgment impossible, end quote. Here, the district court was not simply holding forth on his opinions. Rather, each of the statements to which petitioner objects was plainly made in the course of formal judicial proceedings over which he presided, not in some other context. On these facts, we cannot find that petitioner's right to relief is, quote, clear and indisputable, end quote. We therefore deny the petition insofar as it seeks an order reassigning the underlying case to a different district judge. I understand the reasoning, I just strongly disagree with it. Treason was never part of the proceedings that were before Judge Emmett Sullivan, and he displayed nothing but a deep-seated antagonism to Michael Flynn. But alas, one Flynn, two films. And then finally, the court discusses whether or not the fact that Judge Emmett Sullivan filed the petition for rehearing en banc is sufficient evidence of his partiality, and obviously they conclude no, it's not. Finally, filing a petition for rehearing en banc does not suggest a level of partiality justifying reassignment in this case. As explained, the district judge participated in the Mandamus proceedings at this court's invitation, and nothing about that participation created a reasonable impression of partiality, nor could it. For the foregoing reasons, the petition for a writ of Mandamus is denied. A predictable decision judicially and politically. Send it back to Judge Emmett Sullivan. Let him make his final decision. If it's the wrong decision, then they can appeal it. I think that Judge Emmett Sullivan is in fact biased. I think he has proven his bias. I think he should be removed from the file. But as they say, and as I say, my opinion is worthless. The only opinion that matters is that of the judges. And they have spoken. And with that said, if you like my videos and like my content, please be sure to like, share, subscribe, hit the notification, drop a comment in the comment section below because it feeds the algorithm. If you want to support the channel, all of the support links are in the pinned comment. We've got PayPal, Subscribestar, Patreon, YouTube membership, merch, politics, ruins, everything.
Truest thing on earth.
But more important than all of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out.